Hi, please allow me to introduce myself. My name is Phil Kavesh, and I'm the senior partner of the Law Firm of Kavesh, Minor, and Otis. And as estate planning attorneys go, we're kind of unique because we have this favorite expression that we like to call ourselves, and that is the good guy attorneys. So let's start with number 10. Mistake number 10, letting your family go to, well, I thought there was going to be a blank there. But I usually get a chuckle out of the blank. Okay, you might want to write down the words probate court. Okay, and here there's two forms of probate court that people are not familiar with. This one is the most common. This is when someone's passed away. You go through court, and there's a whole long process to it. But there's also a court process that can occur while you're living when you're ill or disabled. And here, the one that says right next to A1 here, you might want to write down conservatorship. Conservatorship. That's, I call it a living probate because you're in front of the same probate judge in court you may be when you pass, but it's worse because it happens to you while you're living. And you're going to see here today that a lot of what we do in estate planning is not just for after you're gone. It's for taking care of you when you no longer can act. This is really important stuff. Obviously, we want to avoid both court after you pass and while you're living because no one wants the interference of court. It takes a long time to make decisions. You have to hire lawyers. There's delays. There's expenses. It's very expensive, actually. But this is the one that people don't think about. If you're ill or disabled and you fall into a conservatorship, those elder abusers out there can target you as their next victim from the court records because it's open records. And similarly, when you pass away, go through a death probate, well, now those fortune hunters can target your beneficiaries as their next victims. So very clearly, we want to avoid these court problems. Wills and other what are often called simpler planning measures than a living trust just don't do the job. Wills, joint tenancy, there are other probate avoidance alternatives, things like in trust for, pay on death, transfer on death accounts, assets that have beneficiaries to them. And the problem is, first of all, they really, in almost all cases, do not avoid the conservatorship while you're alive, but even when you pass away, even if it has a beneficiary to it. You're supposed to have turned off the phone. 5 demerit points for him. Okay, no more cookies. Okay, all right. And here what I was going to say is that these other options, not only don't they avoid conservatorship in almost all cases, but when that last joint tenant or that last beneficiary passes away, we're back in court again. So there's lots of problems with it, and even tax problems that I won't get into. The bottom line here is that the living trust has become the preferred estate planning vehicle. I used to spend the entire seminar just trying to convince people to do a living trust because I've been doing living trusts since way back in the early 80s when they were relatively new. Well, we've been doing it for over 35 years. We know they work. That's not the issue, and the issue isn't whether most people need one anymore. Now, what is a living trust? It's a document very similar to a will. In that, it names a person in charge. A will, they're called an executor. In a trust, they're called a trustee or successor trustee. A will says who's going to get what and when, and you sign it and date it at the end. Same thing with a trust. So then what is the difference between a will and a trust? It's the second step that occurs with a trust. It doesn't happen with a will and most other forms of planning. And let me show you what I mean. You are the trustor or creator of your living trust. If you're husband and wife, you're both together. Okay, so we get your assets in the trust. You're the trustee, but you also are the initial beneficiary. So you use the assets like you did before. Other than change of title, it's pretty much invisible to you. And during your lifetime, like I said, it's business as usual. You're in control. You can amend or change the trust, or at least your half if you're married, or revoke it, or at least your half if you're married. So it's really a flexible device. It's not etched in concrete. But so why do we do it? Bother putting your assets in it and letting it sit over there on the shelf. The reason we do it is you've got a standby vehicle that's fueled and ready to go because your assets are already in the trust. And someday, your successor trustee, it might be your spouse, it might be a son or daughter or a friend, whomever, is going to step in. They're going to get behind the steering wheel of that vehicle packed with your assets, and they're going to transport them to the people you want to have them. Simple as that. So it's in the garage, ready, fueled and ready to go, which means it doesn't have to go to court first. Because in court, I call it the filling station. When you pass away or you become disabled, the court has to turn over those assets according to title to a new person, which requires a transfer. You already did it during your lifetime, and it doesn't have to be duplicated in court. Now, after just telling you that a living trust can avoid court, here's what I have to share with you, is a lot of the time it doesn't. And why? Because first of all, you have to get all your assets in the trust when you start. This is something we help our clients with, and I will tell you that there are a lot of people who do trusts, and they go, here's some instructions, or here's what you need to do. How many of those people do you think ever get their assets in properly? And so you have no fuel in the tank. The assets you leave out of your trust can wind up in a court conservatorship if you're ill or disabled, or a probate when you pass away. And then there's the issue of this one, which is really a big one. And by the way, for you that already has a trust, here we're on item D2 on the bottom of page 1. I put a star next to it because this is a big failing of people to have a trust. Maybe you put an initial tank of gas in there, right? But if you do that in a car, do you ever have to put any other tanks of gas in after the first one? Yes. And what am I saying? Over your lifetime, you're likely to acquire a new bank account, a new deed, a new stock, whatever it is. And if that doesn't get in the trust, we have a problem. One of the ways that we avoid this, you'll see a little bit later, is we have a very unique service package that we do for our clients where we check in with you periodically and make sure your assets are in the trust. Here's another glitch. You have all your assets in the trust, but you take out a loan. You refinance a mortgage, okay? Usually the lender's going to take it out of your trust. You think it's in there. You sign a whole stack of documents, and lo and behold, when the time comes when you need it to be in there, it's not. And now you're back into court. This is, again, something we check in with our clients about. The typical internet trust and do-it-yourself plan and bargain attorney trusts actually wind up in court. They actually wind up in court. And by the way, this is not my opinion. I will tell you that we handle lots of trusts that other people have drawn, including the clients themselves, over the internet. And because they haven't properly gotten their assets into their trust, the trust doesn't work right, okay? And we wind up in court. Oh, one other thing. Lots of times if people do their own deeds into their trust, they wind up with a much higher property tax bill. Because what they don't realize, it's not just the deed, there's another form that has to go to the assessor's office, and if it isn't filled out properly, it's signed and everything done right, you're going to have a new property tax bill. So getting and keeping your assets in there is key to the proper functioning of your trust plan. All right, number 9, failing to address what will happen when you're dead. Gone is what most people would think, right? But that's not what I had in mind. Disabled. And now we're on the top of page 2, so that's that blank there that you want to fill in on mistake number 9, okay, when you're disabled. And here, the problem is most people think this won't happen to you. Let me share the statistics, and I'll show you how different the world is today, okay? If you are under age 60, there's a 4 to 5 times greater chance that you will be ill or disabled for a minimum of a year to 2 years during your remaining lifetime, over the next 20 years, then you will pass away in the next 20 years. And if you're over age 60, listen to this statistic, okay? There's better than a 70% chance that during your remaining lifetime, you'll be ill or disabled for a minimum of 2 to 3 years, during which time you'll not be able to handle your own affairs. And I can testify to this from my own experience, because when I became a lawyer 40 years ago, time flies, but 40 years ago, that if I had a client who had a heart attack, they had a stroke, they had Alzheimer's or dementia or cancer or MS, you name it, they only lived for a few weeks or a few months, and that was it. Now people with those afflictions can be kept going by modern medicine, which is a great thing. Our life expectancy is longer, but we often reach beyond the point where you can manage for yourself. And I think you'd agree that if this happens, you want to make sure that the right person is in charge and they operate according to the terms you've laid out. Now, part of the problem is that many plans are missing components. The living trust has to be supplemented by other things. There's something called a HIPAA authorization. What is this for? So that if you're ill or disabled, that your financial decision maker, your health decision maker can access your medical information. A lot of people don't know that's restricted now under the law, and even a spouse or child may have difficulty getting to it without the proper authorization. You also need to have the latest healthcare document, and here at item C you might want to write Advanced Healthcare Directive, Advanced Healthcare Directive. And this one is really important because there used to be two documents. I'm not going to go through all of this in detail in a limited time, but you need to have this newer document which takes care of all your health decisions, including all the way to that last pull the plug decision. People don't want to think about, but it's very important that you have the ability to make that decision. Also, this next item, which is interesting, you might want to circle here at D, emergency card. This is not a legal document. This is something very unique to our plan that we do. Think about this. If you got rushed to the hospital today, what do you think's the percentage chance that you're going to have on you your HIPAA authorization and your health care directive? Well, statistics tell us it's less than 1%, right? And imagine the problem now.
When they're created?
Hmm?
Don't you say that to your doctor in your hospital when they're created?
Yeah, but you don't know what hospital you're going to wind up in, and you also don't know whether your doctor is going to be knowledgeable about that at that point in time. How will the doctor even know you've been rushed there? That's exactly why this card is important, because what this card does, we have our clients put it in their wallet next to their insurance card, because that's what the hospitals are looking at, the doctors are looking at. And immediately, by using a special number and access code, we'll send to them 24/7 a copy of your HIPAA authorization, your Advanced Healthcare Directive, and even on the card now, it has the names and phone numbers of the people who are going to make your important decisions, so they can be contacted right away because they don't know you're in the hospital. Also, it can supply the doctor records, the doctor's contact information, and everything. So very important stuff there to have. Also, you need to have what I call a new age power of attorney. Again, older documents. This is one that you might want to put a star next to. And that's item E on the top of the second page. I got to pick up some speed here because I look like I'm going way too slow. But the point I want to make here is that this power of attorney will be important for planning for you if you're ill or disabled, including gaining any government benefits that you're entitled to, and you need to have it. Okay? Now, also here, what about long-term care? What about the cost of that? Here, an important provision that you need to have in your trust and in your will, okay, your power of attorney, excuse me, and your trust, is the power to be able to do benefits planning when you're ill or disabled. And the problem is, when do most people go to do this planning? You're already disabled, right? And the problem is that the standard routine trust, routine power of attorney don't have this. This is an area that we also specialize in, Medi-Cal planning. That's one of the benefits available. And about the only way you're going to get it is by having the right provisions in your trust plan, which a lot of people don't have. Now, mistake number 8, not protecting your beneficiaries from?
Fraud.
From whom? Fraud? Well, that's part of it. No, we talked about the court. I'm going to say from themselves. Okay? Because let me ask you something. How many of you have a huge pile of cash sitting around? Well, hopefully it's at the bank. Okay? Most people don't. If I ask if you're rich or wealthy, most people are going to say no. But I want you to think about this. You're worth more dead than alive. You are. Because when you pass away, your home can be sold. Think about how much equity you might have untapped in there that's now a pile of cash. All your bank accounts can be withdrawn. All your stocks, bonds, and mutual funds sold. All of your retirement plans withdrawn. Your life insurance is cash. The stuff around your home gets sold. The reality is that when most people inherit, the pile of cash they're going to get is way bigger than the pile you have today. You're worth more dead than alive. That's the reality. And the reason we say this is because most people don't think about how much would each beneficiary get. You know, it might be $500,000, $1 million. Well, when people win the lottery with a bunch of cash all at once, what usually happens to them? Now, I don't think I have to tell you, right? And so what we say is trust your trust instead. You may want to have it continue on for certain beneficiaries. So first of all, we're talking about beneficiaries who might be too young. Obviously, they shouldn't get it at 18, which, by the way, that's what the law in California would do. Imagine that. Give them a big pile of cash at 18. Elderly, ill, disabled, drug or alcohol problems. Very clearly, they should have some third-party trustee controlling and spending the money for their needs as appropriate, right? If someone is not good at handling money, they might be an adult, but they ain't good at handling money. I know none of you have one of those beneficiaries, right? Right? They may need a little bit of help with a continuing trust that somebody else handles, okay? Or they're receiving government benefits. Watch what can happen here, because they get this big pile of cash from you, they can lose the government benefit, and even worse, the government could say, great, you got that pile of cash, now reimburse us all the benefits we paid before. So they lost their benefit, and they could lose a big chunk or all of their inheritance. Really bad. There are specialized kinds of trusts that continue after you're gone that can protect these people with a third-party trustee, somebody else being in charge. Now, when we talk about a third party, let me have you put, a star in front of this one. And again, we're on number 8B there. You know, most people, when they go to name the trustee, they say, I want my oldest son or one person in their family that they trust. Is very common. And it sounds good, but you know what? When you have one person in your family lording over the others, you got World War III about to happen. And other people say, okay, I'll solve that. I'll put them all as trustees together, co-trustees. Oh, that's great. They can agree on everything. That'll be World War III also. This one is a big one. You might want to circle professional trustee here, a bank or trust company. And here is something that we're really stressing more and more to our clients. You are much better off to preserve your family's harmony, to have a third party like a bank or trust company be the one that manages things and distributes the assets, because when you leave it up to the family members, it's almost always a very bad situation. Farmers and Merchants Bank also has a trust company. Isn't that a coincidence? Okay?
Did you say a banker trust company?
Excuse me?
Did you say a banker
A
trust
bank
company?
or trust
Oh,
company.
bank or
Some
trust,
banks
okay.
have a trust department, some have a trust company. Here we have a bank who also has a trust company.
Okay.
Okay? So here, another thing is you need ability to adapt, and this is really an important one. I won't go into it in detail, but sometimes you set up a plan 10 years, 15 years, 20 years before you pass away. People's situations change, right? And the kind of trust that you might have made for them may no longer be appropriate. The only thing that most of the time you could do is go to court, and courts do not want to rewrite trusts. They got enough to do. And so in our trust, it has a unique feature that if the circumstances and needs of the beneficiary change, for example, this person that had drug or alcohol problems now has gone through rehab, is tested repeatedly clean, maybe we can distribute some to them. Maybe that's a powerful incentive. And all of these different trusts are able to be adapted into maybe a less restrictive or more restrictive, depending on what their needs are, even after you're gone. Very big power to adapt. Now, number 7 mistake, not protecting your beneficiaries from,
Themselves.
well, we talked about themselves already. Now we're talking about other people out there, what we sometimes call the predators. Okay? And what am I talking about? People say this to me all the time. They say, Phil, you know, you told me about that first set of beneficiaries that had issues. I understand holding it in trust for them, right? But then I have some beneficiaries who are grade A. They're good at handling money. They don't need to have it held in trust for them, right? And unfortunately, one of the biggest mistakes that we see in most all estate plans is this, that people eventually get their inheritance directly out of the trust into their name. And why is that a mistake? Because there's a better way to do it where they can control it and have access to it, but they've got protection. Because they may be capable of handling money, but there might be others equally or greater capable of taking the money from them. What am I talking about? Losing it in a divorce. This is, by the way, the number one reason people lose an inheritance, okay? This one, bad luck. My employer just moves from Torrance to Tennessee. That never happens, right? Or my mortgage, which I got as an adjustable when interest rates are low, it's high now, I'm upside down, I got creditors in bankruptcy, I can lose my inheritance. Somebody files a lawsuit against me, which doesn't even have to be valid, because even if it's bogus, they're going to extort some money out of me, aren't they? And also, this one, if I receive it directly, maybe today I'm your beneficiary and I'm in good shape. I don't need a government benefit, but 40 years from now when you pass away, 40 years enough?
I'll take it.
Yeah. Usually the wife says I want more and the husband says that's more than enough. Okay. But my point is, down the road, that beneficiary receiving a pile of cash might have just lost their government benefit or had to pay it back. Very bad results. And not outright distributions to those grade A beneficiaries, which come out of the trust to them. Instead, using something we call the personal asset trust. And this one is really big. I want you to put a star in front of item C towards the bottom of page 2. This is where, instead of having a third party in control, each of the beneficiaries is capable of managing, gets their own trust that they're in charge of, that they get to manage, control, use, and decide who gets it when they die. Pretty much all the same things as if they received it directly, but instead it's held in this trust vault, which protects them. And some people call this a beneficiary controlled trust. Ours is very unique. Our personal asset trust is actually now registered at the patent office. And the reason why, it allows us to adjust the asset protection level as the beneficiary needs it. Also minimizes income tax when money is kept in the vault. Because a lot of people don't know, trusts pay income tax at a much higher rate, generally, than does an individual. We have gotten around that issue. Now, here, very quickly, I just want to show you how important this personal asset trust, or PAT, is. Here we have first beneficiary, let's say oldest son, it could be anybody to you, who's got a good job and career, good with money. Mom and dad think, we'll just give it to him directly. But if he gets it directly, he can lose it to the spouse in high maintenance spending, you know what I'm talking about, or a divorce. He could have a lawsuit because of what he does or his place of work, or a second estate tax. But by instead having it in this personal asset trust, who's in control? Bob is, he is. Who manages the money? Who gets to use it? He does. Who gets to decide who else gets it during his lifetime and his death? He does. But who owns the assets? Does he own them? Or does the trust own them? The trust owns them, and now he's better protected. Their only daughter, Jane, is also better protected. She may not have the same business experience as Bob, and if she's up against people hitting her up for money, she can bring in a co-trustee. So she can bring in this tough guy here, and every time her husband, Dennis, whom her parents fondly called Dennis the, oh, you know him, okay. Every time Dennis the Menace hits her up for money, she can go see this guy, he won't sign off as the co-trustee. And when she doesn't need him anymore, she can remove him, okay. Or she can bring in the event of a divorce pending, what's called a trust protector, who can actually lock down the trust, keep those assets apart from all of her other, including marital assets, and once the divorce is blown over, reopen it and hand her the keys and the combination. She is now in better shape. And then that younger beneficiary, okay, who we don't know where he's going to wind up. Remember I told you if we knew he had problems, he would have gotten one of those other third-party controlled trusts, right? But maybe he's younger, he hasn't gotten down the road of life yet to know which path he's going to wind up on. Well, if he winds up on the wrong path, the beauty of the personal asset trust is that it can change into a more protective type of trust that will now protect him against those problems. So this personal asset trust, for those who you would normally give to directly. Remember, the ones that have issues, you're going to have a trust with a third party. But those that you might consider giving directly, the personal asset trust is a much better way to go. Now, number 6 mistake. Thinking your living trust covers your assets? No, I'm just kidding. Okay. No, that's not it. It's your IRAs and retirement plans. Because what a lot of people don't understand, and this includes planners, and I'm not criticizing, but I'm just saying that as planners, remember I mentioned, we do a lot of income tax planning. I already mentioned one in the personal asset trust. But also here, because what a lot of people don't realize is when people inherit these types of accounts, they have to pay tax on them, and it happens pretty quickly. Okay? Our goal is we want to stretch out the income tax over the longest period possible. And here, in order to do that, one of the things that we utilize, and we're now here on the bottom of page 3, is we utilize something called an IRA inheritance trust. And what this does is it can allow them to stretch out the taxation over their lifetime, which means money can compound in those accounts longer. And I'm just going to quickly pass through these numbers, but just tell you, if you look at these numbers, are pretty astronomical. A $200,000 inherited IRA, when stretched out properly, is actually over time worth over $1 million to a beneficiary if the stretch out for income tax is done properly. And that can mean the difference to someone retiring or not. Because what's the problem with the younger generation today? Do they have the same retirement plans at work that the older generation had? No, they don't. And so your retirement plans can become theirs with proper planning, with what we call the IRA Inheritance Trust, which is yet again another item that I'm mentioning where our law firm was the first to design this in the country, have it approved by the IRS in a public written ruling, and registered at the Patent Office. Very unique. And what this allows you to do is to not only stretch out the income tax, but protect those inherited IRAs and 401ks and other plans from work, so they can't lose it to the spouse, divorce, lawsuits, and other issues too. Very, very important. If you have over $150,000 in these kinds of accounts, we definitely recommend looking at it. But even if you don't get an IRA trust, one of the things, again, that a lot of estate plans neglect is looking at your beneficiaries to your IRAs and retirement accounts. Because you know what? They override your trust and your will. And if they're not consistent with your estate plan, we got a big problem. And I'm sure some of the trust officers who are here could tell you, they know, they've seen this too many times. Now, the next item, mistake number 5, overlooking other blank tax issues. Let's not use a derogatory term. But most people, when they think about estate planning, they think about what kind of tax? Estate tax, right? But it's not anymore. Really, income tax has become the new estate tax. What is it? Orange is the new black, or whatever it is. And here, what has happened is that most people are not going to pay estate tax. The exempt amount you can pass tax-free is over $11 million for a single person, over $22 million for a married couple. And I hope you have a problem where you have a larger estate. Come see me right after the seminar. You'll become my newest favorite client. Okay. Now, we do planning for estate tax too, but that's not what I'm going to talk about here. Many plans don't address income tax. And look at this, ways to reduce income tax for the surviving spouse. Isn't that important? One of them is making sure that we get a maximum what's called step-up in basis and capital gains for capital gains. Now, let me explain this in plain English really fast. If you bought a property for $100,000 and you pass away and it's worth $400,000 at death, usually what happens is that $100,000 cost base gets stepped up to the $400,000, so whoever inherits could sell it for $400,000 the next day and they have no capital gain tax. So you see, you are worth more dead than alive, right? But here with a married couple, unless we do certain planning, we only get a half step up. So if the spouse goes to sell the home or appreciated stocks after the first died, we could have a problem. We need special planning for that. We also need special planning for this, and that is, what if the spouse inherits the home at $400,000, right? But during their lifetime it grows to $800,000 or $900,000, right? That never happens, right? Okay, and now they want to sell it there's something called a capital gains exclusion for the sale of your home, but it's only $250 for a single person. And without proper planning in the trust, particularly where we have what's called an AB trust, which I'll get into if you want when we get to questions, we need ways to be able to recapture that full $250,000 exemption. With proper planning on our plan, we can do that. Also, we want to reduce income tax for beneficiaries getting a full step of basis when the surviving spouse dies. There's a way to do that that's neglected in most plans that we see. As well as, what if you had one of those beneficiaries that was getting a third-party controlled trust? Remember, if they're too young or they're ill or disabled or they have money spending problems, right? Those kinds of people. When they die and their assets are in the trust, they don't normally get a new capital gains base. We have a way, time-tested and proven, approved by the IRS, which will actually get them a step up. So when it goes to the grandchild, the next generation, they start all over for capital gains purposes. Really a big deal. And by the way, we fix old trusts. If one of you is a surviving spouse and you have what's called a B trust from the first to die, or you have a situation where you're a beneficiary and you already have a trust, or you have something called an irrevocable trust, we can fix all these older kinds of trusts now to maximize the income tax advantage. Huge. This could be hundreds of thousands of dollars. Okay. Mistake number 4, believing the persons who you name to act as trustee will know. Squat, did someone say? Okay. Well, know what to do, right? And this is a really, really important one because most everyone that we see, 95% plus of the people named as a trustee have never done it before. You name a family member or friend, they don't realize this is quite a complex task, and the negative is, you know, the positive is we avoid court with living trust, but the negative is there's no court supervision of everything they do. And they can get themselves in a lot of trouble where they have personal liability out of their own pocket if they do things wrong. So we do several things to help the successor trustee. One of them is an owner's manual book that we give you when you become a client or if you upgrade an existing plan with us. And it includes a number of items, but really the most important thing is, first of all, this item that says checklist of 18 immediate actions. So if you or your spouse becomes ill, disabled, or passes away, the other spouse or your child or whoever's going to step in knows at this point, what are the first things I have to do? And by the way, these do not require a lawyer. You can save them legal expenses and aggravation. Personal directions about smaller items around your home or special funeral or burial wishes, where you keep things, a contact list, names and phone numbers for your beneficiaries, your trustees, other people that you want contacted like your key advisors, and a seminar DVD so that you or whoever steps in can quickly get a snapshot course on how living trust works. But this one is maybe even more important, and here where I am with you is on the top of page 5. And the top of page 5, what I'd like you to do is at item E, circle those words trustee manual. This is one of the most unique things that we do that virtually I don't know anyone else that has this. And we actually, again, have copyrighted this. We license it to other attorneys. This book allows your spouse, your child, whoever's going to be the next trustee down the road, to have a set of plain English checklists that helps walk them through the things that they'll need to do. It's really a key item, and we have found this to be so valuable, even for us as attorneys, because if these trustees called us every day with every question they have, will we ever get any other work done? Probably not. And so we took the most frequently asked questions and we put them into an understandable plain English form, and it even comes with a DVD that's a little bit of a training for them, which is helpful. So that owner's manual and that trustee manual are important. Okay, we're now at mistake number 3, not keeping up with the Joneses, the Kardashians. Anyone else? Okay. The Trumps? Okay. All right. With changes, because here is a big mistake. A lot of people think that living trust is a once and done type thing. You do it, it's over, you put it aside, you never have to look at it, you never have to make changes to it over time. And that's silly because the reality is that your wishes can change over time, even if it's just who you want to be trustee, which, by the way, is the most common thing we see over time. Why? You name somebody and now they've proven that they ain't so good at handling money. Or there was somebody over here you didn't want to act and they've now matured and they are good and you want them to act. So that changes. Obviously, your relationships with trustees and beneficiaries can change over time. There are needs and circumstances. So maybe we want to change the kind of trust that they get, right? We talked about that. Also, there are obviously changes in the laws. Don't shoot the messenger. I don't write the laws. I can just tell you what you need to do. And there are changes in estate planning techniques, like the personal asset trust and IRA inheritance trust that we've talked about. So it's important that you keep up. But also, here's another area where people change over time, using a professional trustee. I will tell you that lots of times as people kind of inch closer to where their trustee is going to have to step in, they start to think twice about maybe that person running everything. And just to let you know, there's a common misperception that banks or trust companies cost more than an individual trustee. They actually cost the same or less because they often have many professionals on staff, which is not an extra charge that a regular person serving as a trustee would have to get all these other professionals and pay additional for. So these are the kinds of changes you want to look at. Now, we're at mistake number 2, man, we're rolling. Okay, mistake number 2, not protecting your trust vehicle with a blank. You bought a car today, or you leased a new car.
Insurance.
Would you ask? Well, insurance is a good one, but not the one I had in mind. At that car dealer, what's one of the questions you're going to ask when you buy it or lease it? What's your maintenance plan or warranty, right? These are the things you're going to ask. What's the service plan? We have a very unique service plan. And I will tell you that over the years, this has really differentiated us from a lot of other people that do trusts. First of all, you call us if you have questions, there's things you want to change. You don't get nickel and dime for a phone call. If you were going to, would you even call us? Probably not. And now your trust is out of date. A free monthly electronic emailed newsletter to keep you informed. Special notices and seminars when there's significant changes. So for example, when we had the new income tax laws that came in this year, earlier this year, we brought all of our clients in for seminars on how you could save income tax. Would you be interested in that? And also when we've had developments like our trustee manual, our personal asset trust, or IRA inheritance trust. Once you become a client, you have a discount on future fees, and this is probably the most key thing, and this is at number 2E. I want you to put a star in front of this one. We're on the last page now. And this one, the free checkup meeting every 3 years is so important because you go to a dentist or a doctor, they're going to occasionally tell you it's time to come back in for a checkup. Why do they have you come in for a checkup? Because they know something's wrong or because you just want to make sure everything is okay, right? And I will tell you the checkup meeting is significant because this is where if there are assets not in your trust, we catch them when we get them in so we don't have a conservatorship or probate. We catch if some of the terms are no longer appropriate to people or you want changes in trustee or there's been changes in the law. Very, very significant. And as part of our service package, the trustee gets a free training. We do these every year now, and a post-death meeting. So we're informing them and keeping them up to speed because your trustee is going to have to step in when you're elderly disabled. Do you want to make sure they're going to know what to do before that happens? Because that's going to impact who? You, directly. So these are all important. Okay, now can I get a drum roll? Anybody got a desk? Can you give me a little drum roll there? Okay, all right. All right, so now we're at number 1. I understand, Phil, how important it is to properly take care of my estate plan, but I'm too, you fill in the blank. You fill in the blank. Because these all fall under the heading of this P word. You know what this P word's about, right? You know what the word procrastinate means, right? I just want to be sure because we had an elderly gentleman recently in an audience. He said, procrastinate? Yes, I've had that operation. No, that's something else. And And this is to put off till tomorrow what you don't feel like doing today. Estate planning is a classic example. And it's what I call the silent killer of estates. Because usually people intend to do the right thing, they just never get around to it. And so let me ask you something very quickly. We went through 10 mistakes. Are any of you making any of these, do you think? Okay. Did you learn anything new here today? Any of you? Okay. Well, that's good, because now what do you do with it? Where do you go from here? You've got some choices. And here, one of the things that we do is we offer you a free attorney consultation, and this is now where I want you to have this form in front of you, the one that says, please take a moment to complete, okay? And by filling this out, we will contact you and set up an appropriate day and time that works for you. And at that meeting, once we have examined you like a doctor, only once we've examined you, your trust, if you have an existing plan, can we diagnose, what's your situation and what's the proper treatment. We can't do that until we actually have a meeting. And at that point, we quote you a fixed fee in writing. But regardless of the fee, would any of you like to get a discount off our fee? I can't get your hands up for that. Come on. Come on, secret Costco shoppers. I'll see you on Sunday.
I want to give you a tip.
Okay. He wants to give me a tip. That's good. Okay. So the first thing is to fill out this response form, and let me walk through it with you. Today, the date is 10/9/18. The location is, you can just put F&M here. Your name and contact information. The best time to call you, because we'll call you to set up your free consultation, and email address, particularly so you can get onto our email newsletter. Also here, you'll see in the middle, how would you rate the seminar 1 to 5, 5 being best. We do appreciate your feedback, unless you're going to write a 1 and forget about it. Okay. Also here, do you have an existing trust or not? Was it prepared by us? And toward the bottom, we have a number of boxes, but the two most key are the first ones. If you do not have a trust plan or an estate plan, you should be checking box 1. If you already have a plan, you should be checking box 2. And the reason why is that when we call you, when we make your appointment, you'll have different items that we'll want you to bring based on whether you already have a plan or you don't have a plan. And so being prepared for your appointment is really important. So we'll collect these in just a few moments. If you haven't finished it now, I'd ask that you please do go ahead and do that.
I have 9 questions.
You have 9 questions? You don't have 10?
And I can go through them real fast.
Okay. Well, I'll tell you what I'm going to do. I'm going to go ahead and just remind you one thing. You can either complete that form and hand it in, or this is the other thing you can do. This looks great on a Saturday afternoon, but it's not so good for your estate plan. So with that, let me ask you, did you learn anything new here today? Okay, do you think this was worthwhile? Then let's give F&M a hand for having put this on today. How about that?